Good afternoon, everyone, and thank you for joining us today. I would like to welcome you to Novus Law Firm and Fortney Scott's Using Lawful Race-Conscious Practices in Admissions, Employment, and Other Institutional Decision-Making. I want to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar box. We will try to answer all questions. This briefing will be recorded. Today's webinar will focus on the lawful use of race-conscious practices in admissions, hiring, promotion, and other institutional decision-making. Attendees will learn strategies and steps that their institutions can take to address these issues and activities proactively. The presenters include attorney Natasha Baker from the Novus Law Firm and Fortney Scott attorneys Elizabeth Bradley and David Fortney. I will now turn the program over to David Fortney to start our webinar.
That's great. Valerie, thank you very much. And thank you everyone for joining us today. It's great, Natasha and Liz, to see both of you again on the screen, as we say anymore, but that's, we have a really timely topic in the use of race and protected status in so many decisions. And so we want to unpack that a little bit. Let me just cover a couple of preliminary matters before we get into that. So first, obviously, although we're talking principally about key legal rules and developments, everyone on this call should understand that we are not intending to provide you with specific legal advice. And I would encourage and recommend that each of you confer with your in-house counsel, your university or college counsel, or your outside counsel as authorized to understand how these developments impact your particular facts. But with that, a lot of this is legal in nature, and we recognize that. And so we are going to provide a lot of very significant legal rules and some very interesting developments addressing these issues. We're going to try to spend the next 60 minutes with you really broken down into three key areas. We're going to start with the foundational elements, the current landscape, what's out there, what's developing, kind of what's on the horizon bit. We're going to talk obviously about student considerations, a very important component in how these rules are applied. And then we're going to spend some time on the employment considerations. So with that, let's jump right in and start focusing on the landscape.
Great, I think that's me. Thanks.
That's
nice
you. I'm sorry. Yes, I should have called you out on that. Yes.
Nice to see everyone again, and thanks everyone for joining us. So as David said, we're just going to first talk about the landscape and what's happening at institutions of higher education. We thought this was a very important topic given the number of calls and requests that we're getting about this topic, which really we've seen an uptick in with the recent diversity, equity, and inclusivity efforts that institutions are engaging in. So we want to make sure that people understand that those efforts need to be rooted in legal principles. So we want to encourage DEI efforts, we want to applaud DEI efforts, but before you roll out a DEI initiative or make an institutional decision that uses race as a factor in the decision making, you have to understand the legal landscape in which you're doing it. Otherwise, your whole program is going to be vulnerable to an attack later, which really, is really counter to what you're trying to do there. So we're going to talk a bit about what we're seeing in terms of trends in institutional actions and DEI efforts. We'll talk about what the enforcement agencies have been doing and recent changes in their enforcement priorities. And then, of course, what we're seeing with respect to civil lawsuits. There's a lot of action out there, so I wanted to make sure that institutions are aware of the vulnerabilities from private lawsuits. So we will go through all of that and really think about the different things, couple table setting things we want to think about before we dive in. So we are seeing DEI initiatives. They have to be appropriately structured, whether it's for students, employees, programs. The roles are slightly different between students and employees. So if you may have done some work with respect to race-conscious decision-making in admissions, that's not the same as race-conscious decision-making in employment. So really making sure that you're parsing what is the institutional action that you're taking in terms of whether you're trying to create a diverse field for applicants, for students, or for employees, whether you're setting aside positions for employees. We'll walk you through sort of all the different ways that this comes up and the legal considerations that you have to have and how those differ as between students and employees. And then of course, we're also seeing race-conscious programs, which we'll address as well. So this might be a club or institution funded club that's only available to members of a certain race. So race conscious programs are we're seeing as well. A couple things to know. So diversity, equity, and inclusivity efforts are lawful. They just have to be, so we don't want to scare you right away as lawyers and say like, you can't do this, you can't take race into account. That's not our goal or our mission here. And we do recognize many institutions are doing the hard work to really have much more inclusive and diverse campus communities. And that is permissible as long as it doesn't stray into the areas of impermissible discrimination. So that's the line we're going to walk here today and talk about how to analyze that distinction. We also want to make sure people understand legally there is a difference concept-wise between discrimination and harassment. So if you make a decision on the basis of race in hiring, firing, promotion, pay, those and you're making that decision on the basis of race, those things tend to be evaluated through the discrimination lens. Harassment based on race, often these two terms are used interchangeably, is really more what you're looking for, the environment. Is there a hostile working environment? Is there a hostile educational environment? So what we're not focusing on harassment today at all in our presentation. Hopefully your DEI efforts are not resulting in a hostile working or learning environment. If they are, definitely give us a call, we'll fix that. But what we're really focusing on is institutional, not individual, but institutional decision-making that could serve the basis for a discrimination claim based on an adverse action. So just some quick table setting there to really think that through, but we are gonna really focus on that discrimination piece. So David, you always have the great DC insider perspective here. So I think you were gonna help us understand, in addition to the DEI efforts that we're seeing on campuses, how are the agencies viewing this?
Sure, I'd be happy to, Natasha, and thank you for that. Those excellent kind of reminders on the legal guardrails, because it's those legal guardrails that the various enforcement agencies, and we're obviously going to focus on the federal agencies, but in some cases there are state agencies that also may come into play, kind of the counterparts, but these are the primary federal agencies and what their portfolio is. We have the Department of Education, Office of Civil Rights, OCR. I think most of you are familiar with that in a variety of initiatives, and may even think of that as kind of the front leading tip of the spear. Hopefully you're not as familiar with the U.S. Department of Justice, and that would be their Civil Rights Division. And the Justice Department, when they do have independent, both investigative as well as enforcement authority, that is through, they tend to file lawsuits that are litigated in federal court. The EEOC, again, an agency that I think everyone is generally familiar with, more often than not, the investigations by the EEOC, just as with, not exclusively with OCR, are driven based on a charge or a complaint being filed. The Justice Department, I would note, does not necessarily require that. It has much broader authority, and it can initiate investigations based on information it learns. It may learn of information through a complaint. It may learn of information through news reporting, social media. There's a lot of ways that the enforcement agency can learn of information and it becomes actionable. The EEOC has rarely used, but it's an important power that even if they don't get a complaint, an individual EEOC commissioner can take action on what is called a charge, a commissioner's charge. And once again, this can be based on almost any information that a commissioner in his or her judgment decides warrants having their agency conduct an investigation. These investigations typically are robust. They involve the ability to subpoena information. You can be held accountable if you don't fully cooperate, and end up even in litigation over the duty to cooperate and provide information. One agency we don't have listed there, but it also can come into play, we're going to talk about this a little later, is the Labor Department. And those of you that are federal contractors, so that's likely a smaller set, has yet another. In the alphabet soup of Washington, you've got one more agency to kind of keep on your radar screen, and that's the U.S. Department of Labor's mouthful, Office of Federal Contract Compliance Programs, or OFCCP. In plain speak, OFCCP is the agency that audits and enforces federal contractors' non-discrimination and affirmative action. That's for employment practices. Now, changes under the prior administration. As I think people know generally, there were a number of landscape changes that the Trump administration introduced. And they did so on a broad basis. And certainly the education field and sector was one of the areas of focus, not exclusively. But there was a withdrawal of a number of guidance documents that provided a level of certainty and clarity on how investigations would be conducted. Those were withdrawn. That's sub-regulatory, so they were simply withdrawn. What that means practically, that if the new administration decides to, they could be reinstated in a similar fashion without notice and comment. There were some very high-profile investigations and efforts initiated by the Trump administration, focusing principally on student admissions. Harvard probably received the most attention, where a very protracted investigation was conducted focusing on Harvard. We're going to talk a little bit about that litigation downstream a little bit, but the Justice Department was the tip of the spear on that. Similarly, the Justice Department, once again, exercising its authority, was investigating other universities, Princeton and Yale, and ultimately actually initiated litigation against Yale. That is, sued them based on their student admission policy. And that lawsuit was very quickly withdrawn in the new administration. But it does underscore the power. The government carries a big stick. And this is one of the points that I really want to make. It's not just private litigants, your current employees or former employees or applicants or even students or people that weren't admitted. You also have the third front is the government. The good news is that in the current environment, the government is going to be much friendlier, we believe. That's our best prognostication. Not going to be as aggressive in terms of some of the enforcement initiatives that we saw in the prior administration. The prior administration made no secret of the fact that it generally disapproved of a variety of affirmative action and diversity efforts, thought they were not legally sound, and took specific actions to push them back. So we're in a bit of a transition period. The page has turned, meaning we have the Biden-Harris administration, and there will be changes. Well, let me stop there. Or Natasha, yes.
Yeah, I just wanted to follow up on your statement about, the DOJ can initiate based on things it hears, things it sees. And if I'm remembering correctly, Princeton had put out a statement acknowledging some of its past practices. And it was on the basis of that statement, among some other things, that the DOJ sort of took notice of what was happening. So you will, if you're engaging in DEI efforts, if you're doing a look back at whether your institution needs to look at reparations or whatever it is that you're doing, this is why your counsel is going to be saying, well, hold on, let's hold off on our statements. Let's craft this carefully. Yes, we want to acknowledge what has happened in the past, but it was that Princeton statement that the DOJ picked up on. So you can do it, just do it.
Absolutely.
Do it well.
And let me pick up on one point on that. We'll use Princeton as a further example. They made the statement, not only did the Justice Department open their investigation, the Labor Department opened an investigation and resulted in a significant settlement that Princeton paid to the Labor Department. So the agencies, it isn't that you settle with one agency and all the others go away. Oh no, they're all have their own lanes and they all run them fairly independently, although they may share information and coordinate. but settling with one or resolving claims with one does not insulate you from other potential claims. Liz.
Exactly. Yeah. So are we moving on to the next slide? Was that the pitch? Okay, great. So going on to that theme of, you may get the agencies off your back, but private litigants don't go away. So just because there may be a change in enforcement theories and methodologies and approaches under the new administration, private lawsuits are not going to go away. And so, we're seeing, and Natasha's going to talk in much greater detail about the student admission cases, Harvard being one of them. We're going to talk about that. But those admission cases are going to continue. Students who are not admitted to the school of their choice are going to continue to raise claims. They'll bring a private action about discrimination or whatever the theory is. Employment cases are still going to be brought. Private litigants are still going to bring individual and or class actions for discrimination and disparate treatment. These you need to be prepared for these. We're already seeing both through the private actions for student admissions as well as employment cases a strong backlash in response to D&I efforts. You're putting a statement out there that you're going to increase the representation of X minority group in your hiring or in your admissions. Members who are not part of that identified group are going to feel slighted. They're going to be feeling that they're not selected. This is resulting in these lawsuits. So we're going to explore various different lawsuits as we go on. But the point here is, just because we're seeing a change in the government enforcement methods and techniques and how they're going to move forward, you can't ignore this fact, and I think there's even greater potential liability and cost to your institution defending and going through these private lawsuits.
Yeah, Liz,
so with that, yeah, go ahead.
Remind everyone that, under the EEO laws, technically everyone's in a protected category. We sometimes hear employers say, oh, well, that person's in a protected category. Everyone's in a protected category. So the backlash is going to come from what are sometimes named reverse race discrimination cases.
Absolutely. And you're seeing that. I mean, there's a large number of these cases that are being brought on behalf of white individuals and or males, which we generally think of as the non-minorities or the more majority. So that is exactly where most of these cases a lot of these cases are coming from in response to the DE&I. So let's move now, get this kicked off, and I'm going to hand it over to Natasha to talk more about, or actually I think I'm staying on this one. Sorry about that, folks. We're going to move into talking about race-conscious decision-making with respect to students. So right now we're going to kind of stay in the lane of students, and we're going to transition to employers in a few minutes. We've touched on this before, but we talk about it in admissions a lot. That's where the buzz is, the cases are, we're Harvard, the Yale admissions, but it's not limited to that. And you need to be thinking about this holistically about all of the programs within on campus. So those race-exclusive student groups, what kinds of benefits, perks are being given to the African-American student group that maybe is not being given to the Asian student group? And think about, is there extra funding? Are faculty members willing to be mentors, or are there some sort of these programs? There are people out there trolling, and they're out on your website. They're looking to see, what are you offering? What are you providing? And if you are giving additional resources or any leg up essentially to any specific race group, that is being a focus and starting to look at that. So you need to be very careful there. Set guidelines. For example, why do you only have an African American group or an Asian group? Are other groups asking to be represented and asking to have these types of organizations? Have strong guidelines. Once 10% or 5%, whatever your numbers are, of want to have it and start it, allow them to come on. Don't be discretionary in that kinds of programs. The other area that I think we're seeing a lot of questioning there is the scholarships, granting of scholarships. And I know Natasha is going to chime in on this in much greater detail later on in our presentation. But that's just a flavor of understanding that this is broader than admissions. Possibly even thinking about it, and we're going to talk more about employment context, but similar, is there student discipline programs? Is there discretion in that based on if somebody gets put on, if they're asked to leave campus, what are those kinds of programs? It's sort of the life cycle and every element of the student campus life and student educational life that this could impact.
Yeah, that's one thing I've seen with the race exclusive student groups is to open up membership to anyone, right? Like that groups the interests of a particular group, but that membership is open to anyone. That sits differently on different campuses in terms of how people feel about that. But you're exactly right that there should be a mechanism for determining when a student group gets institutional funding, because that will be the tie.
Absolutely, absolutely.
Kind of similar to affinity groups that employers often have in their workplace. It's very
absolutely
similar.
Which and you may have on your campus. So there's a lot of these threads. While we're talking about them separately with regard to students versus employees, there's some very common themes that you're going to find throughout both of these. So what laws? What are we talking about here? And this differs a little bit versus private or public. So obviously, Constitution, right? Equal protection. Title VI. Now think about this. You may be a private institution and you think, well, I don't, are you accepting federal funds? Title VI of the Civil Rights Act says it puts non-discrimination obligations in once you are accepting some federal funds. So you need to be aware of that. That is what the cases against Harvard and Yale were citing to Title VI. And that was the hook to bring in under federal law the private institutions. Interesting, there are a number of states that have enacted state bans on affirmative action. List is here, it's 10. Interestingly, California, there was an initiative to withdraw the affirmative action ban last year, and that failed. So there is still a ban in California against doing affirmative action. So you need to be very aware, and most of these state bans are only applicable to state institutions, but you need to be looking at that and looking at what hooks may get to you based on the funding you accept from the states and whether it can be deemed to be applicable to you. So these are sort of the legal landscape that we're looking at and how to properly develop the use of race-conscious decision-making processes with regard to students. And with Natasha, I'm going to hand it over to you now to actually really get into the grit of the case law and how it's been coming out.
Sure, thanks. So, and I will just say that for a long time it was viewed that a lot of the cases were under the U.S. Constitution. They were against public institutions, and they were only about admissions. So I think I did a presentation for Council of Independent Colleges, which is private institutions, about a decade ago, and the real sentiment was this stuff doesn't apply to us. There was Title VI at the time, but it's not just public institutions and it's not just admissions, but frankly that legal underpinning hasn't caught up with the DEI efforts on campus. So if you've been thinking we're private, this doesn't apply to us, or we're private, but this only applies to our admissions, or we don't have an exclusive admissions process, then you also need to be looking at these other decisions that Liz is referencing, because it's all going to be analyzed under both Title VI and likely state law. So I'm going to talk a bit about where the Supreme Court has been on this and where they, are likely to possibly go next. So this takes us back to University of California versus Bakke, and this was the use of a prohibited use of quotas in the admissions process. The Supreme Court, again, ruling against the university, finding explicit quotas to be unconstitutional. So we know most institutions have moved away from using a strict quota system. We have to admit this many of this group and this many of that group. If you're doing anything like that, please take another look at that. If you've got hard numerical targets, anything that could be construed as a quota, percentages, make sure you're looking at that. And then really the Supreme Court cases that are the most helpful in evaluating how you can design a student-focused DEI initiative are the rules laid out in the Michigan cases, the Grutter versus Bollinger cases, and the Fisher 1 and Fisher 2 cases. And so what these essentially say, these cases, this trio says, is that in admissions, public institutions, and we analogize this now to private institutions and to other institutional actions, you can use race as a factor in the consideration of the decision, but it, number one, has to be a holistic decision. It cannot be the primary only factor for making a decision with respect to admissions. And second, it has to be a compelling interest because you're using race, which is normally prohibited in institutional decision-making under the discrimination laws. It has to be a compelling interest, meaning it has to be tied to your institution's mission. Diversity as a goal of your institution, you have to have evidence, and Fisher 2 is a great example of that. You have to have evidence to show we're not just doing this because one element of our campus cares about this, we're not just doing this because we want to up our admissions numbers. We fundamentally believe that our institution's mission is served by having a diverse population, that the education that we offer is better when we have a more diverse student population. So you got to really tie it to that. So it's process, and then it's also tied to your mission. So that's the backdrop against which we've been working for, since 2003, 17, 18 years now, I guess. Time flies when you're having fun. But there continue to be challenges. And if we want to go to the next slide, we can look at how those challenges continue to develop, even though that has been settled for a while. So as Liz indicated, that was against public institutions. Well, the private elite institutions have race-conscious admissions policies as well. So we're seeing this litigated on several fronts. The Students for Fair Admissions is a group that looks for race-conscious admissions policies and will assert lawsuits against institutions where they believe that race is being used as a factor, particular to discriminate against Asian Americans. That tends to be their area of focus, but they're behind a lot of the state law initiatives. They're really focused on this use of this. So we saw that, as Liz mentioned, the case being brought against Harvard. The First Circuit Court of Appeals, again, upheld the university's use of race as a factor, and that's another, that trial was fantastic in terms of the evidence that the university put on to say, from all levels, this is why we value diversity, this is why diversity is a compelling interest. So Students for Fair Admissions recently requested that the US Supreme Court review the First Circuit's decision. Harvard's response was due yesterday. I looked last night, didn't see the filing, but we can expect that they would ask to not have cert be granted. We were talking about this in preparation for this webinar, sort of what is the Supreme Court likely to do with respect to the Harvard case? What's the difference between granting review, granting the petition for writ of certiorari versus actually hearing the case? And David, I think if you wanted to jump in with some key thoughts.
Sure. So it's interesting. Of course, the Supreme Court has 9 judges are called. And in order, they have discretion which cases they pick. So they get thousands and thousands of cases, and they hear a very small subset of the cases that people ask them to decide. In determining which cases they hear, all the judges get to look at all the requests, the petitions that Natasha has described, and decide, should we hear this case? And there's a lot of reasons why individual justices may decide to hear it or not hear it. It requires 4 of the 9 justices to say, yes, let's hear this appeal. Let's decide this issue. And so what the Harvard litigation, so that's what's now pending. It's being briefed up. As mentioned, Harvard's brief is due. Amicus briefs were just filed. The state of Texas filed a very sharp amicus brief in this litigation, making the point, a little inside baseball on this. All of the counsel that are representing the advocates seeking Supreme Court review are former clerks of Justice Thomas. They are very experienced appellate. They have written their briefs and their arguments pitch perfect to pique the interest of 4, if not 5 justices that are frankly quite unhappy with how Fisher has played out, how Grutter has played out, how those cases are being applied. They view that people are actually following a quota approach and improperly using race. So there is a real possibility that this case, the Harvard case, could be the ability with the newly constituted court to revisit yet again these decisions, but dramatically change the direction and the legal ground rules. We'll know by June what they're going to do in this case as it's briefed up.
It could be the vehicle to ban affirmative action in selection depending on how it's ultimately decided.
Yeah, or narrow it so it's unusable, right? Like,
right. Essentially, along with it, right?
And I would encourage anyone who's interested in this to look at the brief that was filed by the litigants challenging Harvard, because they said, look, what they did not only did they show that the policies had a disparate impact on Asians and whites, they showed that different cut points, different cut scores were used, but they also affirm, and the Harvard's own experts agreed that there were disparate results based on the policies they had in place. Then the litigant said, we have other ways of showing and resulting in a very diverse, mixed student population by not looking at race, but by using other factors. And that's one of the proponents, that there are ways that you don't have to use race, looking at socioeconomic background, geographic background, a whole variety of other factors that don't tie to race or gender that could be used, and of course they advocate should be used. So those are the types of arguments that the court, if they accept this case, they're going to be into that hip deep into it.
Yeah. And so we also saw the UNC public institution. There's a trial in November. We awaiting results on how that it's likely to play out, similar in terms of taking it all the way to the Supreme Court if they can. The Harvard and Yale Law Review cases got batted down by the courts. Those were cases in which it was alleged that there were race-conscious criteria used to select applicants to the Harvard and Yale Law Reviews, but those were batted down. And then now Fisher 1 and Fisher 2 obviously involved the University of Texas at Austin, and now we're seeing state law claims being brought against UT Austin. And as David mentioned, the Texas AG did file that amicus brief in the Harvard cert petition. So Texas is not a settled state by any stretch at this point. So that's the issue is not going away. It's heating up. It's polarized. This does not mean we are saying to you, you cannot initiate your DEI efforts on campus. This does not mean that you cannot use race as a factor, because if some of the experts will say using socioeconomic status doesn't help, or using other factors doesn't help. But what you as an institution have to be able to show is we tried to develop a diverse student body. And unless we are able to use race as a plus factor as part of a holistic admissions review, then we're not seeing the diverse results that we think our mission and our values require us to have. So we're gonna, if you want, Valerie, if you could flip to the next slide, we'll just talk a little bit more about some of these best practices. So again, really tying this to your mission and looking at this from the core of your shared governance. It's not enough for your faculty to say we want a diverse student body. It's not enough for the administration to say we want a diverse student body. Not enough to just come from the Board of Trustees. It has to be a core concept tied to your mission, approved by all constituencies within the shared governance structure, and you want to then develop evidence that diversity is a core value, right? So if you're new to DEI, if you're just now implementing it, if you're just starting to think of it, don't have it only come from your Office of Equity and Inclusivity. That's really insufficient. It needs to be permeated across your campus in order to be able to use race as a factor in institutional decision making. So you want to, before our institutions engage in race-conscious decision-making, we really vet that it's coming from all levels. It's reflected in often in their bylaws, the university's bylaws, in their catalogs, and there's a resolution coming from the faculty senate, so that we can really look at where this is coming from and not just from one office on campus. So I will say, just generally, if you want to have a more diverse and inclusive campus, it's my personal opinion, you got to do the work. You can't just say it. You can't just throw out some things and statements or some targeted efforts. You have to build it from the ground up. Number one, so that it actually works, and number two, so that it's legally defensible. So really making sure that if you're going to start making race-conscious decisions, particularly with respect to admissions, student groups, opportunities, mentorships, et cetera, that's on the basis of a shared governance approach. So we'll also next turn to the next slide, and then we'll get into employment, which has a lot of similar themes. But as David mentioned, a lot of under the prior administration, the sub-regulatory guidance was withdrawn. There was some extremely helpful sub-regulatory guidance that was withdrawn, that is relative to the awarding of race-conscious scholarships. So we've seen an enormous uptick in this since, frankly, June of last summer, when donors have started coming forward saying, I want to offer a race-conscious scholarship for Black students. And so institutions are saying, great, we want to do that. We want to figure out how to do that. How do we advertise that? How do we say it? Can we really discriminate on the basis of race in awarding this? So these sub-regulatory documents were withdrawn, but on the next slide, we can look at some of the elements that are important to develop when you're thinking about if you want to offer a race-conscious scholarship. So one of the things that you want to ask the donor is this race exclusive? Is it a preference? Is it race exclusive? Or is it sufficient to have someone who's interested in diversity, but not necessarily a diverse student themselves? Sort of what are the donors' preferences there? What are they really looking to do? Most of the time, they're looking for race exclusive. So again, this similar analysis, again, this is under the withdrawn sub-regulatory guidance, but is useful for designing the parameters, and also incidentally tracks what we saw in admissions, is the consideration of race has to be necessary to achieve mission-related, compelling educational benefits to all students based on documented evidence. It's not just the school's opinion that it would be nice, or it would be better, or it would be an educational benefit to have a diversity. It's actually that you've documented the evidence. So to the extent you're surveying the students, to the extent you can have the faculty discuss this in their faculty senate and weigh in on the compelling educational benefits of a diverse student body, that is going to be necessary as a foundation for awarding race-conscious scholarships. And then on the next slide, we can see once you've laid that foundation, just as you would have done in your admissions process, you also have to really look at the limitations. Even if you've laid the foundation for your compelling educational benefits and mission-related, you also have to look at, is this really, are we narrowly tailoring this? How many of these are we offering? On what basis are we offering this? Is it, if it is race exclusive? I think we maybe missed a slide. If we could go back one.
Go back.
So you have to, once you've tied it to your mission, then say, how many of these do we have? Can we prove that this is necessary to have a race-conscious scholarship? We've tried other methods. We've looked at persistence rates. We've looked at retention rates. We've tried other methods to attract a diverse student body, and it's simply not working. Therefore, as a result, we now think that it's necessary to have targeted race-exclusive scholarships based on the donor's preference. So again, all of this it's all great. It's all things that institutions can do if they want to do. You just have to have the right underpinning, because if you don't, you're subject to attack, and then your DEI program falls apart, and that's worse than not doing it. So, in my opinion. So I'll stop opining, and I'll get my team here.
So I think let's move on to the next slide. I think we tee it up for David. If you'll launch our discussion about the use of race-conscious decision-making regarding employees and employment-related decisions.
Sure. So a lot of the legal landscape, many of the issues are the same, but there's actually some more definitize laws and kind of rules of the road. So we have a little bit longer list of kind of all these different laws that as we're going through thinking about our successful DE&I program in the employment setting, how that's going to work. First, we have non-discrimination laws. That is that you cannot treat one group more favorably or less favorably as a general rule based on their protected status. And there's sort of the familiar laundry list that covers, almost any particular status you can think of in terms of terms and conditions of employment. And it deals with all, and I think we're all familiar with the different protections that these different laws provide. But it's very comprehensive at this point. And so treating people differently, that means either better or worse, because by definition, anytime you treat one group better, you inherently treat someone else less favorably. So it's almost always the case that when you favor a group, you will in return be disfavoring a group, and it's tied to the protected status. That's what the laws are about. Affirmative action,
Absolutely.
yeah, is a little different because it says, look, you have these non-discrimination obligations, race, gender, disability, et cetera. But affirmative action looks and says, we want to make sure that we are doing efforts to reach out in the employment context for recruitment, to make sure that our opportunities, that our funnel, if you will, at the process is as broad as possible so that we get as many different types of protected individuals into the queue for consideration. In terms of how we select them, we don't use discriminatory factors, but we, at least with affirmative action, can overtly reach out and say, gosh, based on availability, it looks like we're kind of underrepresented. We, in terms of our engineers, we have predominantly white, or we have predominantly Asian population. Why don't we have more of another group? Can we do things to try to recruit and create interest among that? Liz.
So David, before we get too deep into what is affirmative action, because we are going to handle that in a few minutes, let's go to the next slide, because I think there's some confusion and let's get some clarity on who is actually covered by the affirmative action laws. And so I'll go ahead and take that. I'll go ahead, since I'm already talking on it. Even private universities, if you have a federal contract or subcontract, you have to engage in these affirmative action obligations. But what is a triggering contract? And there's some confusion we often hear in the higher ed context about whether or not they're actually covered. Grants are not covered. If you accept federal grant funds, that does not make you a contractor covered by the affirmative action laws that were referenced before. And it's the conversation that I think the three of us had with you late last year talking about OFCCP coverage and whether the OFCCP audits are coming, are you covered? So you're not, grants are not. That also includes students accepting federal financial aid. If you have federal financial aid dollars flowing into your university through students accepting those funds, that does not constitute a federal contract for these purposes. That does not make you a covered federal contractor needing to do affirmative action. And finally, to the extent you have a hospital or a healthcare facility as part of your campus and institution, if you're accepting Medicare Parts A and B or Medicaid, again, those do not trigger. So you don't, while sometimes it's nice to say, well, we have to do affirmative action, be careful what you ask for. You don't want to be covered by the OFCCP regs if you aren't. It's not a world you want to be living in. And so you need to be careful there to make sure you know whether you're covered. So just kind of some landscape setting there. And if we move to the next slide, I think we're going to start talking about the distinctions between what does EEO require versus what does affirmative action require. So David, do you want to talk about what EEO requires, since I think I stole the last slide from you?
No, that's fine. So this deals with the not treating people differently based on the protected status. And with respect to Executive Order 11246 and the other federal contractor requirements that we're focusing on here, as well as Title VII, in terms of the whole, think holistically about all terms and conditions of employment. That includes how you hire, how you train, how you promote, which assignments you give, who gets a sabbatical, who doesn't, all the whole holistic view of the employment setting, how the opportunities are made available. And so to the extent that you engage in, if you will, set-asides or walling off or creating special opportunities or privileges for one subset based on race or other protected characteristics, that is potentially subject to challenge. And that's really where the EEO piece fits in most directly.
Think about lab funding. You think about lab funding even. So think of it outside of the context of actual employment decisions, but if you're giving one group additional lab funding and not the other, and that lab funding could ultimately advance their employment, their reputation, et cetera, that's going to be a point. So you need to be looking at this in every element of their employment.
Right.
Sorry, David.
Well, let's talk a little bit about affirmative action. Yeah, you talked about that.
Sure. This is the next step. So this affirmative action is saying that you have to take actions to ensure that all individuals have that equal employment opportunity. The kind of the central theme here is that if you're taking these affirmative actions, sort of helping it along, that absent discrimination, your workforce will ultimately balance out and reflect the gender and racial ethnic profile of the labor force that feeds into it. The concept is it helps level the water. And that is what affirmative action is supposed to be doing. And looking at the next slide, and then I'm going to kind of give a little bit of on this, and then David's got a great way to put it into a great story that illustrates it. Affirmative action is not authorizing you, and I'm saying it is not authorizing you to make any decisions based on race. This is where you're not allowed to set a quota. You're not allowed to do that percentage set aside. You're not allowed to say, I have underrepresentation of African Americans in this group, so my next hiring round or promotion round, I'm only going to advance the African Americans. That's discrimination. It's discrimination against all the other protected classes, to the point Natasha made earlier. Everybody is part of a protected class. But what this is, what affirmative action is, it's taking those additional steps to develop outreach and recruitment. What are you doing to reach out to the areas of which you have underutilization? Are you partnering with community organizations that, I'm going to use African American as an example, but African American employment resources and tools to develop that community and get them interested in your jobs? Are you developing internal talent? Are you looking internally to your campus and your workforce and saying, how do we provide training opportunities, educational opportunities, mentorship opportunities, so that our internal workforce is ready when the promotional opportunities come up? How do we drive and build that, the diverse population from both the outside as well as internally? And Dave, I love your illustration for this, so I'm going to pitch it over to you to tell your story, because I think it really puts it into concept, right, what affirmative action is and isn't.
Right, because I think a lot of people sort of listen to this and go, well, wait a minute, what does all that really mean? You say, I can't have a set aside, but then I'm supposed to do outreach, but I'm supposed to consider race. I don't consider race. So this isn't my explanation, but it's one that was given to me a long time ago by someone, and I think it does a pretty good job. If you are fishing in a pond and all you are catching is trout, you always put the hook in, you always pull trout up. It's like, you know what? I want some different fish. I want perch. I want, you name whatever fish you want to catch. There are two ways we could do that. One, I suppose you could have someone go underwater when you put your hook in and predetermine, based on a quota system, I want 3 bluefish. I'm going to catch bluefish today. I'm going to put bluefish on, boom, 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 and put them on my hook. That, in our world, generally would be illegal. That would be discriminatory. The other way you can do it, though, is you think about it, you're fishing in the pond, you put a greater variety of fish in the pond. And if I want to catch bluefish, number one, I know I've got a lot of bluefish in the pond because I've been stocking the pond. That's affirmative action. I'm taking steps, I'm bringing them in the pond, I'm creating an environment that's attractive. Further affirmative action, I'm using the kind of bait that bluefish like. If that's what I'm looking to catch, I'm going to make it as attractive as possible for them. I'm going to focus on that. And lo and behold, you will find, not every time, but you will tend to raise the percentage of the desired fish that you want to catch. That is an example of not discriminating, affirmative action, stocking the pond, and then successfully catching a more diverse result. And that is very simply kind of a homey example, but I think it does a good job of illustrating what we want you to do, what the law wants you to do, and as a federal contractor, what you are supposed to do. You are to stock the pond.
And I'm going to loop a few concepts together here because we've said, especially employers who have to do affirmative action or want to do these public statements, and I'm going to increase our employee percentage, our minority percentage, or female percentage. We're going to hit 50% female, men, female. We see that, right? Well, once you put these statements out, what if you're currently at 20% female and you're saying you're going to get to 50-50, then you're going to be doing a lot of movement in your hiring. That's that public statement we talked about before that Justice saw. Princeton made out a public statement about what they were going to be doing. We're seeing that employers everywhere, higher ed and not, are making these very bold statements about where they're going to get with their diversity numbers. Be careful there. What are those numbers based on? Have you looked at how much hiring you expect to be doing? One, is that goal even attainable if you did it with all your hiring numbers? And is the only way to get there is if you're only doing the minority or female hiring? And can you really put that out there? So that goes back to the statements of just because you're required to do affirmative action does not mean you're required to get to a certain number by a certain time. And you have to be careful about these very public statements that you're putting out there to get the attention from the private litigants and or Department of Justice, these people who are going to kind of police how you're getting there, because that's starting to sound a lot like a quota, and that is not permitted even if you're required to do affirmative action. And I can feel Natasha wanting to say something. She's coming through the screen at me.
Love this whole topic. Sorry, I could spend all day on this. Yeah, and I was just thinking about, like, in higher ed, we are making these statements, and those, as Liz said, they could be held against you in litigation, but it's also not doing the work. Like, you got to populate the pond, like David is saying. Yep. If you've always advertised in one place, if your search committees are always white, if your publication requirements for your faculty don't take into account structural racism, like if you're always doing what you've done and not fixing the pond, then of course you have to use a quota. Of course you have to impermissibly advance people because you didn't do the work to say we want at least our search committee to look diverse, to talk about diversity on this campus so that people feel, oh, I might be welcome here. So like, it's the tiny intentional things that you do. And then when someone's brought in, do they have a mentor? It's those tiny things rather than the big statements that, like, unless you have a magic wand, like I don't think you're going to be able to meet the statements that you're making. So,
right. Any quick fix is likely going to be reverse discrimination, right? A quick fix is likely the easy. It's going to likely end up being a discriminatory action because a quick fix to get these numbers means you're making decisions based on race. I mean, it's sort of, because it is a bit of a slow process to do this right. It's a lot of work, and you're having to feed in that pool, and you have to continue to be steadfast in your practices that are not based on race or gender.
And I would just say, like, if you are diverse, that's something that you would want to put forth your best foot forward when you're trying to hire employees. If you're not diverse yet, you got to own that, right? There's no pretending like, oh, when you actually work here, we'll be a little more diverse and it'll be better. Like, part of it is doing that internal work to be able to talk about, this is what it would be like here for you, but here's where we're going. Here's where we're trying to go, and here's how we're going to try to get there. It's going to be really important.
Correct. And I think that's a very challenging situation for organizations to own it and then to talk to a diverse candidate about, we are changing and we want you to be part of helping us change and what that looks like. And all the things you touched on, and on both points, because under current, particularly, I'll call it societal pressure, people want to move the needle very quickly, very quickly. Mm-hmm. And they're subject to criticisms from many different stakeholders if they don't move the needle quickly. And all I can say on that is that if you succumb to those pressures, you have the legal risks we've talked about. There are ways of doing this, and you can put metrics in, you can hold yourself accountable. If one method, alternative method, as Natasha sketched out, isn't working, the pond isn't being stocked, you're not getting more diverse fish you're pulling out, keep changing until you find a combination that's successful. Do not simply veer off to what I would respectfully call the lazy way of simply imposing a quota type outcome. That is what you really need to avoid. And there's so many very good, legally good and effective options that don't require a quota.
And also, and we could spend a whole day on this, but my last point on that is it's also really not great for employee morale. I mean, you see that any of your workforce that is not of the targeted protected class is say, well, why do I need to work hard? I won't be promoted anyways because I am not X. So, I mean, there's, in addition to being unlawful, it has significant negative impacts on employee and campus morale. With that, I'll toss it back to Natasha.
Yeah, and I would just say, people want to be hired on merit. No one wants to be like, oh, I was the diversity hire. They want to be the best, and that's what they strived for
Correct.
in their career. So like, it's just, you got to put in the tiny intentional work. Like those smaller steps make so much more of a difference. Okay, there is a tiny exception under the EEO rules, the bona fide occupation qualification, BFOQ in the trade, as we say. And this does allow you to consider a person's sex, religion, or national origin where it's necessary for that position. This really shouldn't be the grounds upon which you are using this. This is like if you've got a women's locker room and you want to hire a women's locker room attendant, you could consider gender on that basis. Where I want to caution higher ed to be really careful about is be careful that you're not requiring that someone's discipline, their academic discipline, requires them to be of a certain race, right? Anybody can study anything. What you really, and the other thing, like if you're looking for people who embrace diversity, you got to look for it in their record. It's not just that they come from a diverse background, they actually have to think that diversity is important. So I would say for these types of decisions, the BFOQ rarely comes up, and just caution you about assigning a certain value to someone just based on their background. So with that, I think I turn it back now to the best practices in using race-conscious policies, which I think we have emphatically hit upon, but just, we've counseled you in other webinars, the fastest way to get in trouble in employment law is to treat similarly situated people differently. Just be consistent. Those standards and methods for hiring, there's so much work you can do in standardized interview questions, in standardized interview approaches, in the training and vetting of search committees to be clear and consistent and non-biased, that people aren't committing microaggressions during the interview process, during the consideration process, during the dinners, if you're still having those. But really what you have to know is unless you want your DEI efforts to be subject to challenge, a protected trait should never be the basis for a hiring or other employment decision. It can be really as what you're looking at more holistically, just like in admissions, but you cannot say, we're going to advance this person, hire this person, et cetera, because of a protected trait. And I think as we've emphasized, that's not really doing the work to ensure you have an inclusive community anyway. So that, in a nutshell, I think is all we wanted to cover. We'll go to the chat to see if there are any questions.
Very good. 1 minute to go. Any questions? And I don't see any questions in the chat looking here.
Great.
All right.
So I forget who wraps us up.
Well, I will then. I think that, so a lot of ground covered. I just would underscore what Natasha just said, particularly most people are still operating virtually, which means you are interacting with people on a screen, and it is even more likely that you may be aware of their protected status based on your visual interaction by seeing them, whether it be a disability, et cetera. So having those standardized best practices are really critical. All right. Terrific session again, and thank you both, Natasha, Liz. I really appreciate the chance to join both of you, subject matter experts, today. I know that you're going to be planning another webinar coming up in the higher ed space in about a month or so. And so stay tuned for those announcements and key developments since then. But I think at that time, you were going to be about 100 days into the Biden administration at that point. So I think it's going to look at, the first 100 days, what the Biden administration has meant, and what the future will hold. So that promises to be a really yet another super webinar. So thank you both very much. And thanks everyone for joining us.
Thank you everybody for attending. Thank you.
Thanks everyone. Bye-bye.
We would like to thank you for joining us. The next Higher Ed webinar will be held May 20th. As a reminder, you may view previous briefings on both the Fortney Scott and Novus Law Firm websites. Everyone who registered today will be registered for all future higher education focused briefings. Be on the lookout for additional updates, which will be sent via email. Later today, you will receive a survey requesting feedback for today's presentation. You are able to submit suggestions for future topics through the survey. Thank you in advance for completing the survey. And of course, if you have any questions, you may submit them via email to info@fortneyscott.com.